కష్టమేమో అని ఫీల్ అవుతున్నాను. And yesterday also there was a very good speaker and now is a bad speaker. Okay, this is my introduction about the good speaker and bad speaker, better and best, good and better and best. I'm trying to be best, not better, not best. Okay. I only raise certain doubts about this act. Any act is made, generally there will be some plus points and minus points. And now why this act is made, this is for contemporary aspiration, that was the one point. The second point is citizen-centric approach is there. Third point is rearranged provisions and merger of certain provisions. This is what it was said. And the wording is, before that, what are the plus points in this act? About the Nyaya Sanhita, the offences and punishments written together as far as possible. There are one place there are definition, the other place is a punishment. Now that was removed almost all in all the provisions. The offence and punishment written together generally. Anyhow, the change is better. The general principles are the same. That is the criminal principles of that is means area, actus reus, all these things that was not changed. However, new crimes were introduced in the Sanhita, and some offences were deleted. Some provisions were made general neutral. There are marital rape was not made an offence. However, there is a lot of discussion and debate about the marital rape. If this is included, there may be chances of breaking of the marriages, families. That was the reason. It was a discussion. And some anomalies were corrected. That is the age of the child. Sometimes it was mentioned as 15 and 18. Those was corrected and mentioned as only 18 now. The other one is the community service. That was newly introduced for only for certain offences. Community service is there, but there is some drawback is there in the community service. We'll come to the point later on. And there is enhanced punishments are prescribed. There are so many punishment is enhanced and minimum punishment is prescribed. Minimum punishment is rarely we come across these things in the earlier Indian Penal Code. Now we are the concept of all the legislators and also the academicians that we are traveling from punishment to justice. I don't understand whether we are traveling to punishment to justice. The penal provision was removed and it was mentioned as Nyaya. There are so many provisions, punishments were increased, and another one is the minimum punishment is prescribed. How we are going to Nyaya? That was the question. But they are talking about the victim point of view. Now, when we are dealing with the cases, we don't deal not only the victim, but also we are concerned about the accused person and also the society at large. These are the public duties of a judge. We have to see that the three things have to see: the accused, victim, and justice. Before going further, what is the Constitution says about Article 21? The Article 21 says, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now, yesterday we have discussed about the procedure. There are some provisions were not dealt in detail by the learned guest. I don't know the reason for it, but anyway, I will try to discuss those 2-3 provisions in detail, and thereafter we will proceed for Nyaya Sanhita. The next provision is the another article in the Constitution is Article 19. Article 19, what it says: protection to certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech, expression, assemble peaceably and without arms, to form association or unions or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of the territory in India, to practice any profession or to carry on any occupation, trade or business. Now this is what these two provisions, why I am referring articles. One is Article 21 and Article 19. Whether these articles are protecting the rights of individual and also the citizens. Now Nyaya Samhita, including the BNSS and BSA, whether they are protecting the rights of citizens, he may be an accused or he may be a victim. This is my doubt. I am not giving any conclusion. I firstly said. Now the basic point is my feeling is that how far the nomenclature of these acts, that is Bharatiya Nyaya Suraksha Samhita. It is very difficult to pronounce this Bharatiya Nagarik Suraksha Samhita. Then next one is, what is that? Bharatiya Nyaya Sanhita. The third one is Bharatiya Saksha Adhiniyam. After seeing this, I came to know about what is mentioned, what is the meaning of Adhiniyam. This is nothing but Sanskritization or Hindi is being thrown away. The language problem issue also there. Whether it is according to the Constitution, this is my basic question. What the Constitution says about nomenclature of the statutes. But anyway, you all know that how these statutes came into force. All the opposition leaders were thrown away from the parliament, and thereafter the bills were moved and acts were enacted. Now they are coming to force by 1st July 2024. I thought that it will not come into force, but anyway, there is a possibility of coming into force by 1st July 2024. Now for this purpose, I will read out Article 348 of the Constitution. What 348 of the Constitution says? The language of the Supreme Court and High Courts, etc. Not only the High Court and Supreme Court, what is the language of the acts, ordinances, etc. The language of the court, the language to be used in Supreme Court and in the High Courts, and the bills are notwithstanding anything in the foregoing provisions of this part until Parliament by law otherwise provides, all proceedings in the Supreme Court and every High Court and authority to texts of all bills to be introduced or amendments there to be moved either House of the Parliament or in the House of Legislature of the state, of all acts passed by the Parliament and Legislature of a state, and all ordinances promulgated by the President or the Governor of the state, and all the orders, rules, regulations, bylaws issued under this Constitution or under any law made under Parliament or the Legislature of the state shall be in English language. What is the word? Shall be in the English language. But why the Legislature has not made the language of all these three laws? They are forcing us to read Sanskrit or Hindi. I am not criticizing, but this academy is meant for debate and discussion. I am raising this point. When I was working as a senior civil judge, I raised this point, but some of the judges did not allow me to speak at the time. I told them on the dais itself that if you are not allowing, there are so many forums for me to discuss and debate. Therefore, now the point is, now the stage is for discussion and debate. You can freely discuss and debate of all the provisions, and I am not giving any conclusions. Only I am raising certain issues, whether it is correct or not, whether these acts are in favor of the people or not, whether these acts in favor of the accused or the victim or not. That is my question. Whether these acts are in favor of the victim, forget about the accused person. Whether these acts are in favor of the victim, so many people, so many speakers will say that so this act is favorable to the victim. My personal view is that this act is not in favor of the victim also. Okay. Now this is first point is the Nagarika Suraksha, Nagarika Bharatiya Nyayarika Sanhita, Bharatiya BNSS and BSA are all to the against the Constitution. That is the provision Article 348 of the Constitution. This is my first doubt. You have to clarify whether my doubt is reasonable or correct or not. Next, coming to yesterday, our friend discussed a lot about the various provisions of the Criminal Procedure Code, that is BNSS. I will discuss three of the provisions about the BNSS, and thereafter we'll go further go into the Nagarika Nyaya Samhita. Now, before going further, I request all the officers to see there is a provision, it was likely discussed by our friend in page number 107, section 107. BNSS. Because some certain clarification required from the point of view of the academy, therefore I am discussing these provisions. After discussing these provisions, we will go further about the Nyaya Sanhita. What this provision says, where a police officer making section 107, sir, 107, page number 69. Okay. Yes, attachment and forfeiture or registration of property. What it says, where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of criminal activity, any property derived, how the police are conducting investigation, how they are making use of every provision and every law, how they are misuse every provision and every law. That is the reason we are worried about all these provisions. Now this is section 107. And now where a public police officer making an investigation has reason to believe that criminal activity or from the commission of any offence, he may with approval of the Superintendent of Police, what is required? Approval of the Superintendent of Police or Commissioner of Police, Superintendent of Police or Commissioner of Police make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offence or commit it for trial, the case for the attachment of such property. Therefore, a police officer can file an application before the magistrate or before the session judge for attachment of the property. That he is having right. Only thing is he has reason to believe. That is sufficient cause. Sufficient cause is there. He can file an application under section 107 for attachment of the property. What is necessary? Any property is derived or obtained directly or indirectly as a result of criminal activity. That is first point. The magistrate has to do. If the court or the magistrate has reason to believe whether before or after taking evidence that all or any of such properties and proceeds of crime, the court or the magistrate may issue a notice. It is the duty of the court or the magistrate, they have to issue the notice. Thereafter, calling upon him to show cause within a period of 14 days, that is the time is given for 14 days as to why order of attachment shall not be made. Therefore, police have filed application under 107 subsection 1 and magistrate or the court has issued a notice asking the person to give his reply within a period of 14 days, that is under subsection 2. And next coming to subsection 3. This is only for the first two provisions are accused person. Now we will see whether the notice issued to any person under subsection 2 specifies any property is being held by any other person. If the property is held by other person, if the property is purchased by some other person, if the property is in the custody of some other person, then on behalf of such person, okay, a copy of the notice shall also be served on such person. Therefore, third person can also notice can also be given to the third person. Next, the fourth section. The court or a magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material fact available before such court or magistrate, and after giving a reasonable opportunity of being issued to such person or persons, may pass an order of attachment in respect of those properties which were found to be in the proceeds of crime. This is, I mean to say that this provision can be exercised by the magistrate or court before conclusion of the trial, before giving any finding. Now, the question is whether innocent persons may suffer by this provision or not is my doubt. I am raising doubts. I am not giving any answers. I am raising only doubts. This is my doubt or questions. Next, fourth. Not only that, and the court can pass an ex parte order also in criminal side. Now, this is fourth one. The court or the magistrate, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material fact available before such court, the magistrate, and after giving reasonable opportunity of being heard to such person or persons, may pass an order of attachment in respect of those properties which are found to be proceeds of crime. If the magistrate comes to a court or magistrate comes to a conclusion, that is nothing but found to be proceeds of crime, then he can pass an order of attachment. Next, provided that if such person does not appear before the court or the magistrate, this is important, or represent the case before the court or magistrate within a period of 14 days specified in the show cause notice, the court or magistrate may proceed to pass an ex parte order. Now, is it favorable to the victim? Is it favorable to the accused? To whom it is favorable? It, according to me, it is favorable to the state, not to the any person. This is lots of powers are given to the state and the police, not to the victim or accused. This class may be a different point of view from yesterday's class. Yesterday class was only from the point of view of the, according to my assessment, my understanding, from the point of view of the state. Now I am talking about from the point of view of a citizen, from the point of view of the citizen. Now, this is ex parte order can also be passed, provided if such person does not appear. Number one, he does not appear. Number two, within a period of, does not represent, within a period of 14 days, specified in the notice, the court or magistrate may proceed to pass an ex parte order. Therefore, the court is having power to pass an ex parte order for the attachment of the property. What the next step? What is the next step after attachment? Next, we will see. Section 5. Notwithstanding anything contained in subsection 2, the court or magistrate is of opinion that the issuance of the notice under this subsection would defeat the object of attachment of this or seizure. If the magistrate comes to a conclusion, if the police tries to impress upon the magistrate that it will defeat the purpose of the object of attachment and seizure, the court or magistrate may, an interim order, pass an ex parte direct attachment of seizure of such property, and all such shall remain force in so and so. No, sorry. If the court or magistrate finds attached seizure properties to be proceeds of the crime, only point is he should see that whether the properties are proceeds of crime or not. How he will come to a conclusion that proceeds of crime? The material placed before the magistrate, or else he has to examine. This is silent. Whether he has to examine the evidence, again mini trial will take place for the purpose of attachment of the property. The court or magistrate shall by order direct the district magistrate to rateably distribute such proceeds of crime to the persons who are affected by such crime. Therefore, this is also by direct, he can order for distribution of the property. What he has to do, on receipt of the order passed under subsection 6, the district magistrate shall, within a period of 60 days, the time is 60 days, distribute the proceeds of crime either by himself or authorize any officer subordinate to him either to effect such distribution. That is next point. 8, subsection 8. If there are no claimants to receive such proceeds, or no claimant is ascertainable, or the surplus satisfaction of claimant, such proceeds of crime shall stand forfeited to the government. Now, this is the, in what offense, for what offences section 107 can be invoked? This is silent. Even for every offence, the police officer, I am pinpointing that the police are misuse every provision. There is no dilemma, no nothing else for me that they will misuse every provision, and this is the provision they will misuse this provision, and therefore why I am making it, don't fall in the trap of the police officer, don't pass any order. However, it is your discretion, but you exercise your discretion judiciously. Exercise discretion judiciously when the petition is filed under section 107 of the CRPC. This is one point I want to, this was not discussed in length by yesterday by our friend. I am not criticizing him, that is his point of view, this is my point of view. It is the decision to be taken by you while dealing with the cases. Now the other point is, the most important point is whether this act is in favor of the, now there are certain provisions are there, punishment was increased, number one, and there are certain provisions are there, minimum punishment is there, therefore some justice is being done to the victim. We can say that some restoration is there, okay, compensation is there, okay. Now the point is how the Lalita Kumari suffered for lodging of a complaint before she has to knock the doors of the Supreme Court simply for registration of the FIR. When there is no Lalita Kumari case, what it says, every information relating to the commission of a cognizable offence, it is the duty of the police officer in charge of a police station to register the case. There is no option for the police officer. Though there is no point in going further that whether the police officer is entitled to see that whether the information is credible information, whether the information is reliable information, that is not the stage for him. Only the stage he has to register the case whenever he receives information. Only 2 points. Information must be relating to commission of a cognizable offence. That is the point. If it is a cognizable offence, there is no option for him except to register a case. Therefore, that is the situation. Now, whether that situation is continued or not, now what the police officer is having power, how many there are, what is this provision 173 says, now we have to look into it. Next, everybody is claiming that there is a zero FIR is there, we have introduced the zero FIR, therefore it can be useful for the zero FIR. Now my basic question is, zero FIR concept is there from the beginning of the 1974, from 1st April 1974. What it says, there is no question of reference of any jurisdiction when you read section 154. But at the same time, if you read section 155, there is a distinction is there, that is within the local limits of his police station. In a non-cognizable case, the police officer cannot go further. Therefore, when you read section 154 and 155 of the CRPC, we can come to conclusion that there is a provision in 154 that the zero FIR concept is there prior to the Nirbhaya case. But however, after Nirbhaya, it was focused because the police have not registered the case, therefore that was discussed and debated at length. Therefore, this is the provision. Now the question is whether zero FIR concept is useful from the point of view of the accused, from the point of view of the victim. This is another question. Because in Narayanagouda police station where I reside, the police is not favorable to me. They are not in a position to register my case. But in Vemulavada, my native place, the police officer is very close to me. Therefore, he can register a case for my behalf. Therefore, can I go to the police station of Vemulavada and lodge a complaint or not? There is a scope for misuse by the victim, the so-called complainant, and also by the police officer, whether he can go to where the police officer is amenable to him. I am not talking about native place, where the police officer is amenable to him, and thereafter he will lodge a complaint and he will issue the FIR. And the question is issuance of the FIR, whether he has to issue the FIR or not. Certainly, yesterday he was telling that issuance of the FIR is not necessary. Whether FIR has to be issued or not, according to the provision, he has to issue the FIR. And simply, what step he has to be taken after the issuance of the FIR? The act is silent. Then, why this act was without discussing and debate, were thrown on the public? That is my basic question about this act. Number one, zero FIR. And there are a lot of consequences by the zero FIR. I am not saying that zero FIR is not advisable. Therefore, zero FIR is necessary. But there is a chance or scope of misuse of the zero FIR, especially more particularly in cases of 498A, in so many any other case, 420 or any other case, there is a chance of FIR. There is a chance of misuse of the power given by the zero FIR, either by the police or by the victim. Now I am talking about the next question is electronic communication. What it says, if it is orally 1 point, another one subsection 2, Roman 2 says, it shall be taken on record by him being signed within days. For a moment, an accident occurred in front of the academy. I made a telephone call to Maradpalli police station that please, this is the information, somebody killed or somebody road accident took place in my place. Therefore, I left to NJA for purpose of training. Can I go to the police station and sign on the report within a period of 3 days? Is there any scope for me to sign in the 3 days? Or else my administrative officer can sign in the police station? If not signed, whether he issue the FIR or not. There is a possibility of issuance of the FIR or not. Only telephone information or WhatsApp information or email, so that was sent. Now the question is, electronic communication, it shall be taken on record by him on being signed within 3 days. If I not signed within 3 days, what is the fate of the complaint? Now, what is the fate of the case? For murder took place in front of the academy. For God's sake, it will not happen. But anyway, this is giving an example. It is a serious offence. Therefore, it is a bounded duty of the under 37 of the Old Act, and as a citizen, dutiful citizen, I have to report the matter to the police officer. The administrative officer is a matter of his duty to inform the police. It is my duty to inform the police because I witnessed the incident. I informed the police. telephonically or else by email or by WhatsApp or something. I have informed him. After information, within 3 days, I have to sign it. I left to USA. Therefore, my son is staying. I left to USA and the evening itself. Therefore, there is no chance for me to go to the police station and to put my signature. Now the act is silent about it. What is the fate of the incident? What is the fate of the first information? Whether it can be issued or not? This act is silent. Oh, huh? Chapman.
Is it not better than giving the report belatedly, whereby the case ends in acquittal?
No. The question is my doubt is I am raising my doubt. The question is whether he will issue the FIR on the information or not. Whether he has to wait for my signature.
Okay, sir. Within 3 days that can be done. But
Okay.
it is my opinion that instead of giving the complaint with delay,
Okay.
it is better than
Okay.
that.
Not that it should be treated only as an information.
Okay. Information and it should be now generally telephone information is there. Telephonic information, that is 157. What 157 says? Information or otherwise. Information or otherwise. What is the meaning of otherwise? The police officer can suo moto issue the FIR. I have made a telephone call to the police officer. Therefore, we will come subsequently also. We will see certain other provisions also. Then I will come to your question. Now, whether there is a delay. Now, whether delay is the concern now or not is the big question. Because first of all, the basic provision is section 154. That is the FIR. Now, this is 173. The next question is a remand, and that is 187, I think, 187. And the third provision is how a complaint has to be filed before the magistrate, how he has to take cognizance of the offence. These are the things. Now, the point is, what is the law laid down by the Supreme Court, the 5 bench judges in Lalita Kumari? Lalita Kumari case is preliminary inquiry, not to conduct entire preliminary inquiry. The preliminary inquiry to the restricted is only to know whether there is a cognizable offence is taken place or not. That is the scope of inquiry. The scope of inquiry Lalita Kumari is only to know whether there is a cognizable case is there or not. That is the scope of inquiry. Now, what is the scope of inquiry under this provision? We will come to that point. Therefore, now how a victim will face lot of inconvenience for getting register of the case. That is my point. Now everybody is saying that this is Nyaya Sanhita. All these provisions are in favorable of the victim. I mean to say this is not in favorable of the victim also. This is in favorable of the police, in favorable of the state, not in favorable of the any accused also. Therefore, why I am raising this question, because all the officers are here. You can exercise your discretion in favor of the victim, in favor of the accused, in favor of the society. Therefore, we are like empire. We have to see the victim. We have to see the accused. Simply because that fellow is an accused, we are not supposed to punish him. Therefore, there is every scope for so many false cases being booked against a person. There are a lot of scope. Do you mean to say that what Supreme Court said recently, by acquitting so many people, they are unnecessary, they have filed? How many days they spent in the jail? Almost 4 years or 5 years, I think so. I forgot the name. What is that case, sir? Huh?
20 years.
20 years. That is the why. Therefore, the first point is number one, zero FIR. The concept of zero FIR is not new. It is available in section 154 itself. If you go through section 154 and 155, you can clearly say that it is only zero FIR concept is there. There is no reference of any within the jurisdiction. That point is nowhere it's mentioned. And there is decision of the Supreme Court, that is Punit Ramlu versus the state. Yesterday also it was referred. Punit Ramlu decision was there. And thereafter, now we're coming to other provision. The only point is a copy of the victim, if it is registered. If it is registered, a copy of the FIR should be given to the victim and also to the accused person. If it is not registered, there is no question. Because why I am making it is, because if you go through say other provision, that is subsection 3, without prejudice to the provisions of section 175 on receipt of information relating to the commission of any cognizable offence which is made punishable for 3 years or more but less than 7 years. This is the word used as 3 years or more but less than 7 years. The officer in charge of a police station may, with the prior permission of the officer not below the rank of deputy police, considering the nature and gravity of the offence. What is the word used? Considering the nature and gravity of the offence. Then he can make a preliminary inquiry. That power is given. Throwing away the judgment of the Supreme Court in Lalita Kumari case. In Lalita Kumari case, the limited scope was there. What is the limited scope? Limited scope is to know whether there is a prima facie case is there or not. That scope has gone now. What is happened now? Now, what is the word used here? Considering the nature and gravity of the offence. Now, court has to see, the police officer has to see, considering the nature and gravity of the offence. What he has to see? He can make a preliminary inquiry. Only for that purpose, he require prior permission from the Deputy Superintendent of Police. Now, if it should be given, proceed to conduct preliminary inquiry as to ascertain whether there exists a prima facie case or proceeding in the matter within a period of 14 days. It is the duty cast upon the Deputy Superintendent of Police. He should grant the permission within a period of 14 days. That is the tagline fixed. For a moment, another question. Is there any, he can proceed for, he requested for permission. Is there any time limit is prescribed for the Deputy Superintendent of Police? For grant, 1 minute. A Deputy Superintendent of Police, any time limit is given. In such a time, he should grant the permission. He has not granted the permission. Then what is the duty of the victim? She has to bribe the police officer. Only thing is, what is the scope for other, any scope is there or not? No, Srinivasa Reddy, Chappandi.
Sir, all this is intended according to our preliminary understanding
Huh.
to benefit the accused. Why? Because if the investigating officer doesn't register the complaint, doesn't register the report and issue an FIR,
Huh.
the other option available to the victim is to approach the magistrate to file a private complaint.
No, please tell again, sir.
If the investigating officer
Hmm.
for some reason or the other fails to register the complaint on the basis of a report lodged by the victim, either it may be either by oral information or by way of electronic mode of communication, the other option that is available to the victim is to file a private complaint before a magistrate.
What are the steps required for private complaint?
Before taking cognizance of a private
No,
complaint,
I visited the police station.
Please. But before filing a private complaint, taking cognizance of that private complaint, notice has to be issued to the accused.
Okay.
This is 223. So accused is being now brought on record to resist the cognizance that is to be taken by the magistrate. So earlier there was no such provision. Now again, if this provision does it not favor the accused or not? We will also think in this angle.
No, that is okay, fine. It is favoring the accused, number one. Now, I am talking about the plight of the victim. I am talking about the plight of the victim.
This is also plight of the victim, sir. Unnecessarily he has to again face the mini trial at that stage.
Yes.
Before cognizance also mini trial is provided.
Yes, exactly.
If police regularly register the case, there is no necessity of bringing the accused at that stage. We cannot hear the accused at the stage of registering the complaint.
Then how can we say that Nyaya Sanhita?
That is what, sir. This is
No, this is debatable. We are talking, we are making as a debate.
We are not
We are
criticizing.
not, okay, we are not criticizing, even though,
Not intended to straight away criticize the enactments,
Okay.
but we are debating.
debating. But please.
I will characterize it like this. In 1898, when the Criminal Procedure Code was first enacted, we were under the colonial rule.
Yes, sir.
It was a sword. Yesterday, our speaker was giving an example of a scalpel that can be used as a weapon. I will say this is a sword. The colonial state created this to keep us under its boots. In 1973, after independence, when this was amended, I would say only amended, it was not a new code. Only certain modifications were made to bring in line only for small changes.
What is the change? The change in the name.
Name.
Major change is in the name. Okay.
Then not much change. Maybe little bit about remand, little bit about notice, capital procedures was changed. Now what changed now is only name. And then the sword, if it was really intended for the protection of the citizens, it should have been made into a scalpel, not a sword. The sword remained and it was sharpened and made more heavier. That's all that had happened.
Okay, now the question of delay, what about the delay? Now I visited the police station, I lodged a
There is
complaint.
no option, sir.
There is no option. The police officer says, I sought the permission from the DSP, I am waiting for the permission of the DSP, therefore you wait. Therefore, the victim has to go to the DSP and impress upon him, either by this way or that way, sir, you please give the permission for making preliminary inquiry by the police officer in charge of police station. Then at last, by any way, I have to go to the MLA and impress upon the MLA to please inform, make a telephone call to the DSP for making a preliminary inquiry. Again, now what is the inquiries to be done under this provision? What is this is more, what is the nature and gravity of the offence? The scope of Lalita Kumari is not the nature and gravity of the offence. The scope of Lalita Kumari is to know whether there is a prima facie case, whether there is a cognizable case is made out or not. And so the scope is enhanced. Now, how the court will interpret these provisions, that is the big question. How the court will understand whether our view will be considered by the various courts or High Court and Supreme Court, it has to be seen. But
Entire process, the causing disappearance of evidence is a direct possibility.
yes,
And the offender may fleeing from the justice is also another possibility.
definitely.
So, how these two things have to be correlated.
No, therefore, what I am saying is that,
Preservation of crime scene and evidence is of the paramount consideration of the police. If they take their sweet will and time in registering the case and commencing investigation, then it would certainly cause great deal of prejudice to the victim.
Now, Dr. Sonu Srinivasan contradicted himself.
Sir.
Earlier he said that it is
See,
favorable.
this is regrettable. I am
I'm
Okay.
also with you.
Okay.
not contradicting
What I want
anybody.
to add is,
ah,
This
please.
is only to bring out the lacuna
Yes,
or
yes,
legislative
yes.
Okay.
inadequacies and deficiencies.
Okay.
not only is that,
But
because the
we will listen to Mr. Patavi.
crime needs immediate consideration, whether it is good, bad. When FIR is to be registered, it is Lalita Kumari in fact is a dent to the CRPC.
I agree.
That exceptions in
I agree.
is debt.
Hmm.
Somehow Honorable Supreme Court has created several dents, it's one of the dents. Okay. Now, they made it statutory. This is first, not only first, several are there, this is one of the lacuna. And regarding the PMLA provisions, almost the PMLA provisions, Parliament knows that Vijay Madan Lal Chaudhary is being reconsidered.
It is pending for reconsideration.
In
the July.
It has to come, now it is posted to July.
Okay.
Last week we are expecting. I was expecting that many of these provisions would be declared unconstitutional even before they are commenced. Because if Vijay Madan Lal Chaudhary is reconsidered as we are expecting, that liberals in this country are expecting, and if the liberals' view is accepted by the Honorable Supreme Court, these provisions which now our directors are read, they become unconstitutional.
One writ petition was filed, it was not taken up by the Supreme Court.
And now it is posted July. Reconsideration is being done.
Okay, okay,
To July they have posted it.
okay. This, about these acts,
No, sir. PMLA.
PML, okay.
The provisions which they have included in that 107 and other provisions.
107 is nothing but bringing, making inroads into the CRPC.
Yes. And
Grounds
sir,
of arrest, reasons of arrest, interpretation of section 19 that Pankaj Bansal versus DD of Enforcement Directorate.
and if all of us remember that when we came to early days of practice, that criminal law amendment August 1944 was there for PC Act. Is an act which says that the proceeds of crime can be attached. At that time there was a debate under the criminal law amendment ordinance. Though the case is being tried by a special judge under PC Act, civil attachment to all these things were earlier conferred on only on district judge, not on session judge. There was a debate. They said that no, district judge is a civil man. These are all rights of people on property are included. Therefore, district judge should do. It's not session judge because criminal court should not investigate into the rights of the parties over the immobile or mobile property. That was the earlier wisdom of judiciary, law, everything, including judicial limits. Now that is slowly eroded by PMLA. The PMLA provisions are now brought into the Sanagarik Samhita. Whatever Nagarik Samhita, Ranagarik Samhita. We have to say it appears to be that something which we are not able to pronounce, we should call it Ranagarik. So now, if the PMLA provisions are invalidated by the Honorable Supreme Court in July, actually I have expected to be in June. I was dreaming that okay, before commencement some of these provisions would be declared unconstitutional. And soon, if our view is, I mean, now I should not say our view, if view of liberals is accepted, definitely these provisions, so all those who are acting under 107, please wait up to July, August, so that we get the judgment so that these provisions will be invalidated. And this again, there is some strange argument, Nyaya Sanhita, because we don't want to punish. After you are putting our punishments in penal code, and you are saying it is not for punishment, or what? You have to call penal code as penal code. What is this Nyaya Sanhita? Again, they are changing into some Hindi, Arabic, whatever they can do. But that should be coherent, reasonable. That Nagarika Samhita is, we are not protecting anybody. And particularly, Indian judiciary has the reputation of being equal to your foreigners also, not to citizens.
Because 21 says, okay.
Yeah, that's actual 21 is giving for every person. So these are some things, but what all the points are raised, all you are raising only debatable points, and all are. I agree with you in many.
Okay, thank you. Next coming to the other question, sir. This is only considering the nature of the gravity of the offence. Now, how he will come to the nature of the gravity of the offence? He has to conduct the investigation without issuance of the FIR. What is the value of the statements recorded by him? We don't know. Therefore, thereafter, any person agreed. Okay, next coming to. No, this is regarding to the 173. Now we will proceed for 187. This is 187. Next coming to page number 113, 112 or 113. Now next for this purpose we will see section 480, 245, page number 245. What section 245 says? That is third proviso is there in the 480. The 480 says regarding the grant of the bail in non-bailable offences, there is a provision was there simply because the accused was necessary for the purpose of conducting of TI parade, bail should not be refused. Bail should be granted even though TIP parade was pending. What is the object of behind that TI parade? The object is the TI parade should conduct expeditiously as possible. That is the concept. Now, what is the concept of police custody? That also, why should we grant the police custody? The basic question I am asking. Why should we grant the police custody? Immediately after the issuance of the FIR, number one, you should proceed to the spot. Number two, number three, you should inquire into the matter of the cases, you should examine, and all these things has to be conducted. Last, what is the last step in the investigation? Discover and arrest the offender. That is the last step in the investigation. Now, what is the first step in the investigation? Since last 30 years, the first step in the investigation is the arrest of the offender, and we should go to the evidence. Now, we are going reversely by not going from evidence to accused. We are going from accused to evidence. Now, therefore, in my suggestion, my understanding, I am not giving suggestion, it's my understanding, we should discourage the police custody as far as possible. We should not give the police custody for total period of 15 days. But there are two things. Whatever I say, you act according to your judiciously. I am not I am not a Supreme Court or anything else. It's only my point of view I am discussing with you. Therefore, what is the scope of section 480 third proviso? Now we will read out section 480 third proviso. That the mere fact that the accused person may be required for being identified by witnesses during investigation or police custody beyond the 15 days shall not be sufficient ground for refusing grant of the bail if he is otherwise entitled to be released on bail and gives undertaking that he shall comply with such directions as may be given by the court. Therefore, simply because police have not taken to custody, don't refuse the bail if he is otherwise entitled. Only rider is if he is otherwise entitled, don't refuse the bail. Simply because the bail, now what is the provision? We have read it now. No person shall be deprived of his life or liberty except according to the procedure established by law. Simply because some allegation was leveled against a person, he is not an offender. He is not an accused. He has not committed the offence. It's only allegations leveled against him. There are so many cases are being filed against the politicians or so many people. They may be real or may not be real. And it is for us to see whether to grant the bail or not to grant the bail. I have come across a Supreme Court is granting stay against the granting of the bail. This is the situation prevailing in the country. Supreme Court is granting, High Court has granted the bail, Supreme Court has suspended the bail. It is better to cancel the bail instead of suspending the bail. And in the Supreme Court, I forgot the name of the accused person, his bail petition was come up before the Supreme Court for 15 times for bail. Whenever you see the rules of practice, we should give precedence to which one? Sir, criminal cases and also the liberty of a person. We should hear the bail applications first. We should hear the sessions cases first. I am not saying, the rules of practice is saying the same thing. Therefore, now the point is, the entire law in the country is going against the accused person. I am not taking an accused person is a innocent or not that. He may be a culprit. He may be he might have committed offence. That is a different matter. But we are as judges. We should be like umpire. We should see both sides and we should involve. Now, my point of view in this case that simply because police custody petition was not filed, you don't refuse the bail. Depending upon the situation, case to case, you please grant the bail. Therefore, that's not the criteria. That is the third provision of 480. Okay, this is only the 3 point. 223 is there, and we have discussed about the 223. Now, what is the scope of 223? Next, we will come to this provision Nyaya Sanhita. Next, coming to decoding of it, whether the objective of the law is to punish. Now, it is only objective of law is only to punish and do the justice to all the persons. Okay. Next, so many academicians are saying that it is meant for doing justice. My point of view, it's not only it is doing for justice for the victim, but victim is also a sufferer for registration of a case, and all these things are there. Therefore, the basic provision, at least this provision should not be forced enforcement loki raakunda chuste better, except only at least section 173. It should not come into force. 106 subsection 2 of IPC, BNS was not come into, will not come into force. Okay, next coming to what this act is. Okay. This act may be called as Bharatiya Nyaya Sanhita. It shall come into force from the 1st April. Okay. Every person shall be liable for punishment under the Sanhita and not otherwise. 1st July 2024. Sorry. Next, any person liable by any law for the time being in force in India or to be tried for an offence committed beyond India shall be dealt according to the provisions of Sanhita for any act committed beyond India in the same manner as if such act had been committed within India. Okay, that is section 4 was there. Now, the provisions of Sanhita shall also apply to the offences committed by any citizen of India in any place without beyond India, any person, any ship on any ship or aircraft registered India wherever it may be, any person, any place. Okay, next coming to the illustration. Okay, territorial, the jurisdiction is territorial, extraterritorial, admiralty and personal. And what the BNS exception to BNSS, punishing mutiny or desertion, the same, special laws, local laws. Next, the preliminary. Now only the thing is the chapters were made as 20 and sections were made as 358, and there are some beautiful provisions. Things were done by some alphabetical order was mentioned in definitions, and definitions were made in section 2, all these definitions. Therefore, in punishments and definition was made in one section. There are general exceptions are the same. Punishments, only one provision was incorporated in the respect of punishments. That is only community service. Again, this is also a debatable question, and discretion is given to for the purpose of community service. Now, what is meant by community service? Yesterday, Mr. Chandru was saying about some conditions were imposed by the judges of the various high courts, including not only the district judiciary. What they are imposing, you please if bail will be granted if you pay so and so amount to the victim. Bail will be granted if you distribute the Bible. Bail will be granted, conditions are for the bail should be granted if you distribute the Quran, if you do the service. What are the conditions to be imposed while granting of the bail? What is the purpose of granting of the bail? This is the basic question. I do not understand why those conditions are being imposed by the various courts. That is the basic question. Now the question is community service. Now what is meant by community service? Well, for community benefit he has to serve. Now one person think that he should sweep the roads, or else he should work in a old age. There should be some scope. But what is the default? Any default provision is there for community service? The act is silent. I am not doing community service. What is to be done for imposing of community service? That's the big question. Now, I am not giving conclusions. Only please, everything is only for debate and discussion. And you have to come to your conclusion, or you have to wait for the decision of the High Courts and the Supreme Court. Now, this is the regarding to the punishments. Yes, sir.
A conditional order can be imposed that in case of default, he
Huh.
will undergo some imprisonment
Okay.
or fine. If the
Or fine.
provides for fine,
Okay.
he shall be imposed to pay.
No, then I'm saying that we can do it, but this act is silent if there is community service is there. My simple question is I am questioning the drafting of the legislation. The legislation should say like that. We can interpret, because now it is the time for all the judges in the country to interpret the laws. We have not come across to interpret the IPC. I have not the occasion to interpret the CRPC, because CRPC came into force on 1st April 2024. Now this opportunity is given to all the judges. You can interpret the law according to your understanding, as rightly said by Srinivas Reddy Garu. What he says in default sentence. Therefore, that is the question. Why? Because I raised this question, some answer has come. What is that answer? You can impose the default section, but the act is silent about the default. Next, offences for death penalty. What is?
Until it is not provided, we cannot impose it.
What, sir?
Unless and until it is specifically provided,
Okay.
court cannot pass.
Okay. Okay.
Punishment should be in accordance with the.
Okay.
Section 8, subsection 5 speaks of
ఇది చెప్పండి సార్ 8(5) అని చెప్తుంది.
Section 8, subsection 5. The offences
పేజ్ నెంబర్ చెప్పండి ఒకసారి. ఆయన దగ్గర వేరే పుస్తకం ఉంది. పేజ్ 29.
Section 8, subsection 5.
ప్లీజ్ చదవండి. ఇఫ్ ది అఫెన్స్ ఈస్ పనిషబుల్,
Fine or community service.
Hmm.
The imprisonment which the court imposes in default of payment of the fine or in default of community service shall be simple.
ఓకే, ఇట్ ఈస్ ఆన్సర్డ్. అంతేనా? ఐ విల్ రీడ్ అవుట్. ఇఫ్ ది అఫెన్స్ పనిషబుల్ విత్ ఫైన్ ఆర్ కమ్యూనిటీ సర్వీస్, ద ఇంప్రిజన్మెంట్ ఫర్ which the court imposes in default of payment of fine or default of community service shall be simple, and the term for which the court directs the offender to be imprisoned in default of payment of fine or default of community service shall not exceed 2 months. Okay. Some default is there. Okay. Now coming to other points. This is another one. A punishment for rape causes death or results of persistent vegetative state of mind. Section 66. Gang rape 72. Punishments awarded BNS. Death penalty is awarded. Now there is a murder for 103. This is lynching. Next, punishment for murder for life convict 104. Mandatory death penalty was struck down by the Supreme Court in case of Mithu versus State of Punjab. That is the reason the legislators have mentioned that is the another point. What is the punishment prescribed for all this rape or all these things? Life imprisonment till remainder of life. I think so. Abatement, attempt, waging of war, dacoity accompanied with murder, and imprisonment for life, which shall mean the remainder of the person's natural life. That is the now the power of the state government or any government was taken away by the statute. The state government cannot reduce the sentence because remainder of the life is mentioned. That the imprisonment for life, which shall mean that remainder of the person's natural life. Therefore, there is no question of any invoking of section 433 or 433A. All these provisions are taken away. Only the power is given to the governor and also to the president for extending the pardon. Except that, nothing else. Therefore, rape of a person in authority, rape of a woman under 16 years of age, rape of a woman under 12 years of age, these are all removed, gang rape, etc. Now community service, okay, we have discussed about. Changes in terminology. This is the one other. Minor is replaced with a child. Gender includes the transgender. Movable property of every description, corporeal or incorporeal. This concern is now the Burma Commission recommended the use of outrage of the modesty of a woman. In POXO cases, it was removed. Huh? Concern. And this is the concern of the various people in the country. What is that concern? They should, what they think that outraging the modesty of women should not be used. Now the point, because Burma Commission also requested the legislator not to mention as outraging the modesty of women. After the POXO is there, in the POXO, outraging the modesty of women word was not used. It's only assault was sexual assault, all these things were used. But in this act, the same word were used for outraging the modesty of a woman. Now this is another addition. This is addition. A person abates of an offence within the meaning of the Sanhita, who without the beyond the jurisdiction abates the commission of a offence, any offence in India, which would constitute an offence if committed in India. This is a new provision incorporated. If any person outside India abates, he can be brought to the law. Now the section 63, sexual intercourse of sexual acts of a man with his own wife, the not being a wife of 18 years of age is not a rape. Okay, that is a 12 years to 15 years, all these things were removed. Now it's only 18 years. Now this is another important point, section 69. What section 69 says? Whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same, has sexual intercourse with her, with sexual intercourse not amounting to rape. Now we have removed section 497. Now whether there is some argument, 69 attracts 497, because 69 lo ekkada em chepparu, only the word used is the married woman అని ఏం చెప్పలేదు. ఏమన్నారు? Whoever deceitful means promise to marry a woman. Unmarried woman అని ఏం చెప్పలేదు, married woman అని చెప్పలేదు. There is a possibility of filing of a case similar to that of 497 by invoking this provision. That is section 69. Whoever, that means by deceitful means or by making promise to marry to a person without any intention of fulfilling the same, has sexual intercourse with such intercourse not amounting to rape, and shall be punished with imprisonment of either description for a term which may 10 years. Only here unmarried women, not married అనే పదం చెప్పలేదు కాబట్టి married women మీద కూడా there is a scope for filing of a case against a married woman by his husband. Therefore, though we have removed, deleted 497, there is a scope of invoking section 69. Only for discussing. Okay. I'm not saying I am not giving any conclusion. Now again I am saying that this is the possibility. The possibility.
It's not 490, my opinion is not 490. Such cases, it cannot be committed against a married woman.
No, you are interpreting in such a manner. Our friend, other friend will interpret in this way. There is a scope of interpretation.
Married woman means wrong, sir. But there are offences which are impossible to commit.
In case if you promise, if you obtain divorce from your husband, I am ready to marry.
Okay. Now anyway, we will see. Now this is the okay. I am not saying this way or that way. I am making some doubt about my doubts. I am raising my doubts. Okay. This is my doubt. Next, coming to 95. This is hiring. This is a new provision. New provision 95. Hiring, employing or engaging a child to commit an offence. Whoever hires or employs, engages any child, commit any offence. Okay. Now this is this offence. Punishment murder. We will proceed further. This is the more important. This is group of 5 or more persons acting in concert commits a murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished imprisonment for life and shall also be liable to be fined. This is section 103(2). This is mob lynching. Mob lynching, that word mob lynching was not mentioned in this particular section, but indicates about the same mob lynching is coming in this way. Therefore, this is about 103 subsection 2. 103 subsection 1 is the murder. Now, next question is 106. As you know that this will not come into force. 106 subsection 2 will not come into force. Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. అంతకుముందు మనకు 304A, what is the punishment prescribed in 304A? Only 2 years. And now the another feature is, you please see all the provisions. There is punishment and fine. Most provisions are punishment with fine. Only we'll see the R fine. R fine is very few, where punishment and fine. Now this is also may extend to 5 years and shall also liable to fine. Therefore, ఏమన్నా bailable and unbailable చూడండి. Okay, but there is an exception to the medical practitioners. What the medical practitioners? A registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description which may extend to 2 years. For medical practitioners, okay, our Patabi says this is also against the Article 14. But why the discrimination against the medical negligence for the doctors only for 2 years? Why they for others that is 5 years? This is a debatable question. Okay.
స్ట్రైక్ చేశారు. అందరికంటే ముందు ఐపీసీ కొత్తది వాళ్ళే స్ట్రైక్ చేశారు.
ఓకే,
వీళ్ళకేమో డాక్టర్లు అని చెప్పి వాళ్ళకి తక్కువ.
అందుకే ఏమంటున్నానంటే ఫస్ట్ ఐ రిక్వెస్ట్ ఆల్ ది పర్సన్స్ టు రీడ్ సెక్షన్ ఆర్టికల్ part 3 of the constitution. Therefore you may discuss and debate all the provisions whether it is constitutionally valid or not.
Sir, there was some discussion on this particular provision. Distinction was sought to be made. That doctors do an act with the purpose of saving the life.
Okay, doctors who are doing for saving of life.
Yes.
Okay.
But by doing any rash and negligent by any person who drives a vehicle, normally, normal parallels if we take it, this can only be invoked when motor accidents take place. So that is done with the purpose of unknowingly causing death. But
Okay.
doctors with all knowledge and future forethought they will do.
Okay, right, sir. Okay, this is only for our, we have to implement the law and we have to interpret the law. For interpretation is a little scope is there. For implementation of law is lot of scope is there. Now we will see what doctors are giving the benefit for whatever may be the reason, that is the punishment is only 2 years and shall also be liable to fine. Now the next point is without reporting. It will not come into force, I think so, but anyway, escapes without reporting it. If he reports, he will come under 106. 106(1). If he not reporting it, he will come under the definition of 106 subsection 2. Subsection 2, what is the punishment prescribed for this one? Which may extend to 10 years and also liable to be fined. Lot of serious offence was considered. Now this is another important section. Only 3 sections. Now why I referred Article 19? By referring of Article 19, whether now the only 3 provisions, that is 111 and 112 and what is that 142 or 152. So next, what is meant by organized crime? Related to organized crime is there, the definition is there. Next coming to any continuing unlawful activity including kidnapping. Now see how many offences are there. Kidnapping, robbery, it is it's including. They have not, don't think that these are the offences. There are so many offences. They included only few. Therefore, police officer may include any other offence. Therefore, every chance of including of other offences, they may making as a organized crime or petty organized crime. Now we are seeing the organized crime, including kidnapping, robbery, vehicle extortion, land grabbing, contract killing, economic offence, cyber crime, trafficking persons, drugs, weapons, illicit goods of service, human trafficking for prostitution or ransom by any person, number 1, or group of persons acting in concert, singly or jointly, either as a member of organized crime syndicate or on behalf of the syndicate, by use of violence, threat or threat of violence, intimidation, coercion, or any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute a organized crime.
డౌరీ డిమాండ్ కూడా వస్తుంది సార్.
ఎక్కడ?
ఫైనాన్షియల్ బెనిఫిట్ ఉంది, డైరెక్ట్ ఆర్ ఇండైరెక్ట్.
No, that is includes definition. You can include so many offences. Not only why only dowry death? Why only dowry death? Okay, next. Organized crime syndicate means a group of two or more persons, only two or more persons who acting either singly or jointly as a syndicate or gang indulge in any continuing unlawful activity. Now, continuing unlawful activity means an activity prohibited by law which is cognizable, punishable with imprisonment for 3 years or undertaken by any person either singly or jointly as a member of organized crime syndicate or on behalf of such syndicate. Okay, this is the organized crime. Now we will see petty organized crime. That is 112. Whoever being a member of a group, therefore if there are two persons are there, simply police officer will say that it is a petty organized crime. What are the offences in this? Theft, snatching, cheating, unauthorized selling of tickets, even black tickets, unauthorized betting or gambling, selling public examination question papers, that is also there. Public ఏమంటారు? అది petty offence. That petty organized crime, not petty offence. Okay. చూద్దాం. Okay. For the purpose of this section, theft includes trick theft. Trick theft అంటే ఏమిటో తెలియదు, ఎక్కడ కూడా చెప్పలేదు. ఓకే ఓకే attending diversion. Okay, next. Theft from vehicle, dwelling house, business premises, cargo theft, pickpocketing theft, though card skimming, shoplifting and theft of ATM. Okay, this is another one. This is the most important. It is defeating the. Now there is a provision is there already. UPA is there, but instead of UPA is there, this is terrorist act was incorporated in the Bharatiya Nyaya Sanhita. Now there is a difference between Nyaya Sanhita and UPA Act is there. UPA Act, who is having power to investigate. The persons who are having power to investigate is not below the rank of DSP, and the other provisions are 43, I think 43. On my NIA, but anyway, in the case of CBI, that is Delhi Police Establishment, the cadre of Deputy Superintendent of Police, but in the metropolitan area, Assistant Commissioner of Police. In the case of NIA, not below the rank of Inspector. This was a change made in the year recently, about 3-4 years back. That was coming into force by 2019. Earlier, it was not below the rank of DSP was there. Now it was made mention by NIA. If NIA is investigating, it should be investigated by not below the rank of Inspector of Police. Now what is required in the NIA UPA, subject to correction by my friends who are dealing with the case of UPA cases. Now the point is, if they want to make any search in Hyderabad, they have to seek the permission from the government. That is the provision is there. Now those things are gone now. Now who can investigate? Any officer in charge of police station can register a case under the Terrorist Act and they can make an investigation. No sanction is required, nothing is required. It has made as a just like any other offence. Now it is, this is, now what is UPA is a special legislation. Okay, something is mentioned, but anyway, this is explanation 133. Superintendent, next, voluntary causing grievous act. 117 and to 114. I will read out on my book. Whoever voluntarily causes hurt, if the hurt Yeah, that is, we will read subsection 3 and subsection 4. So, subsection 4 is mob lynching, and subsection 3, whoever commits an offence under subsection 1 in the course of such commission causes any hurt to a person which causes that person to be permanent disability or in persistent vegetative state shall be punished with rigorous imprisonment for a term, with a term which shall not be less than 10 years but which may extend to life imprisonment. He shall mean imprisonment for the remainder of the person's natural life. That is the punishment given. Just now I said, now there is no discretion for the government to reduce the sentence by invoking section other provisions. Therefore, this is subsection 3. Now subsection 4, when a group of 5 or more persons acting in concert causes grievous hurt to a person on the ground of his race, caste or community, sex, place of birth, language, personal belief or any other similar ground, each member of such group shall be guilty of the offence or causing grievous hurt and shall be punished with imprisonment of either description which may extend to 7 years. Therefore, this is the punishment prescribed for mob lynching, and other provisions are there. Next we will go to, this is the most important provision, is section 152. The government is claiming that they have removed sedition, but sedition is removed or sedition is there. This is sedition plus, not only sedition, sedition plus, more than the sedition. What the sedition says, whoever purposefully or knowingly by words either spoken or written or signs or visible representation or by electronic communication or by use of financial mean or otherwise excites, don't be excited yourself, excites or attempt to excite secession, even if you are making of any other division in any state, that is also declared will be, they can be prosecuted for the offence under section 152, that is secession or armed rebellion or subversive activities or encourages feelings of a separatist activities, endangers sovereignty or unity and integrity of India or indulges in or community, any such act shall be punished with imprisonment for life or imprisonment which may extend to 7 years. And this offence is cognizable but triable by court of session, non-bailable. Now this is section 152. What is the, they have removed section 124 from the IPC and they have incorporated section 152 in this act. Next, coming to comments or explanation, Kedarnath Singh, okay, assaulting obstruction. This is another one, assaulting or obstructing public servant when suppressing riot. This is fine is imposed, shall not, fine less than 25,000 rupees, the increasing of the fine amount. Next, coming to suicide. This is section 2 side. Whether suicide was removed, 309 was removed. Now what it says, whoever attempts to commit suicide with intent to compel the restraint or public servant in discharge of official duty. వాడు గొడవపైకి ఎక్కేసి దానికి ఎక్కేసి గొడవ చేస్తుంటాడు కదా, చచ్చిపోతాను దుంకేసి, వాడిని ప్రాసిక్యూట్ చేయడానికి అవకాశం ఉందా లేదా అంటే, దిస్ వాజ్ 309 is repealed but because of Mental Health Act 2017. What it mentioned, whoever attempts to commit suicide with intent to compel the or restrain any public servant in discharge of his official duty shall be punished with simple imprisonment for a term which may extend to 1 year or with fine. Here or with fine is mentioned, or with both, or with community service. Now community service is also mentioned in this offence. Therefore 226 ఏమంటారు,
whoever to restrain, compel or restrain అన్నారు కదా సార్. ఇప్పుడు సపోజ్ అసలు ఆయన చేయట్లేదు అన్నప్పుడు నేను సూసైడ్ చేసుకుంటా అనేసి ఇక్కడ అటెంప్ట్ చేయాలా, థ్రెటన్ చేస్తే సరిపోతుందా? అటెంప్ట్ చేయాలి. అటెంప్ట్ అంటే గోడ మీద ఎక్కేది కానీ అటెంప్ట్. ఇప్పుడు అటెంప్ట్ అనేదాన్ని మనం హి హాస్ టు ట్రాన్సిట్ దట్ వి హావ్ ఏ గుడ్ డెఫినిషన్ ఆఫ్ అటెంప్ట్ సో ఫార్. ఇక్కడ అటెంప్ట్ అనే థ్రెటన్స్ అని ఉంటే బాగుండేదేమో సార్ అసలు యాక్చువల్లీ.
ఓకే, ఈజ్ ట్రైయింగ్ టు పోర్ కిరోసిన్ పోసుకుంటున్నాడు, కిరోసిన్ పోసుకున్నాడు. మురళి ఏమంటారు?
That is not an attempt. We are pouring kerosene or wearing towel with akatam, that is not an attempt. He must jump.
Okay, now what I said that it is a time for you to interpret. when a remand is placed before you under section 226, you have to interpret in such a manner as you understood the provision.
Not be read for 307. 307, the act must be completed as part of the appeal. For some other reason, it must be.
Okay.
not acted.
Okay. Now we will see. Now we will read again. Whoever attempts, that's the word used. Now, whoever attempts to commit suicide with intent to compel, that is the necessary, with intent to compel the public servant from discharging his official duty shall be punished with simple imprisonment for a term which may extend to 1 year or with fine or with both or community service. Okay, next. 304, the snatching. It was there in the Haryana and some other places, but it was now included in the Bharatiya Nyaya Samhita. Theft is snatching if in order to commit theft, if the offender suddenly or quickly forcibly seizes or grabs or takes away any person his possession of movable property. This is also a punishment new incorporated. And 324, 321, for 341, there are two offences now coming to 356. Now repeal, as you know that the Indian Penal Code is hereby repealed. Notwithstanding anything repeal of the code referred to subsection 1, it shall not affect the previous operation of the code so repealed or anything duly done or suffered thereunder, any right, privilege, obligation or liability acquired, accrued or incurred under the code so repealed, any penalty, you know that Article 20 Clause 1 or that is any and also 20 double GFRD ex post facto laws and all these things, and now any penalty or punishment incurred in respect of committed against the code so repealed, in investigation, remedy. Okay, next. Any proceeding, this is thoughts, notwithstanding such repeal, anything done or in any action taken under the said code shall be deemed to have been done or taken under the corresponding provisions of this Anhita. That is the only point. Next is the mention of particular matters in subsection 2 shall not be held prejudice to the effect of general application of section 6 of General Clauses Act. Okay. Now this is the effect of the repeal. There is no question of it is repealed, but it is in existence for the up to 12 o'clock January 31st, June 30th, 12 o'clock. What is the offences committed? This act applies. IPC and CRPC Evidence Act applies. After 12 o'clock, the new act will come into force. Okay. For those offences, only old act will play. Now, what are the changes introduced? Section 48, Section 69, Section 86 and 95, 103, subsection 2, 106, subsection 2. Next one, organized crime, that is 111, one petty organized crime, 112 and 113, Terrorist Act, 173 clause 2 and 4, voluntary causing grievous hurt, 152, endangering sovereignty, unity and integrity of the India. Only the 195 2, assaulting or obstructing public servant when suppressing riot, 226, attempt to commit suicide and snatching, mischief, property offences 314 and 314 3 and 4, defamation and repeal in savings. And what are the repeals? 124A repealed, but it came into force in another way. And abetting in India is repealed, making or selling is repealed, thug is repealed, unnatural offences. This is another question is, if a man committing unnatural sexual intercourse with another animal, now what it constitutes, what are we has to say for this answer? And because he is, no, whether it removal is correct or not, to what extent it is to be removed or not, that is the question to be debated. For 477, lurking, house trespass and house breaking, and 497, you have to discuss about read with section 69 along with 69 of the BNSS. You should see that whether adultery can be done or not. Some concerns, 87, 26 is there, and miscarriage, and 377, deletion of 377, it should have been retained in watered down form to protect consensual sexual homosexual acts among consenting adults while criminalizing those without consent. That is number one. Moreover, the expanded definition of rape says sexual acts include penetrative action against any part of woman's body. Any such acts when committed by husband upon their wives are protected under the marital rape exemption. Okay, that is another. Assault and gratify unnatural lust, that is also a point to be noted.
During the judicial separation, it was covered.
During the judicial separation, not covered. I think so, not
Covered.
covered. ఎంత చెప్పండి. ఎంత అండి 57? 67. Okay. Now, these are the points. I am not talking about negatively about this acts, but only I am making my doubts, my questions regarding the acts, and it is for you to, but anyway, lastly, the change is for better. Offences and punishments were mentioned in one section, written together, that is also good. And new crimes introduced because there is a contemporary aspirations will be there. Because of the contemporary aspirations, some new offences have to be included. But anyway, the word colonial, always the people will say that colonial laws are removed. It was not removed, only some amendments were made, that's it. New crimes were introduced and some were deleted, and most of the offences were made gender neutral. Most of the offences were made as gender neutral. Marital rape was not considered, and community service was included. Enhanced punishment and minimum punishment for fine was imposed. These are the things now discussed. But anyway, this is in brief about the BNSS. Sir, BNS అంతేనా? మళ్ళీ కన్ఫ్యూజన్ వస్తుంది. BNS కదా ఇది. మనకేదో ఐపీసీ సిఆర్పిసి ఎవిడెన్స్ యాక్ట్ అంటే ఈజీగా ఉండేది, ఇప్పుడు అది కష్టం అయిపోయింది. ఇంకా కొంతకాలం పడుతుందేమో, చూద్దాం. బట్ ఎనీవే, థ్యాంక్స్ ఫర్ యువర్ లిసనింగ్ అండ్ ఫర్ ఇంటరాక్షన్. థ్యాంక్ యూ వెరీ మచ్, and we will meet again after the break.